Hi, this is John Harrison with the law firm of Hickman Lowder, and I'm here with my colleague, also an attorney at Hickman Lowder, Blaine Brockman.
Hi, John. We're here today to talk a little bit about the issue of home care waiver disenrollment, some trends we're seeing in this. The problem, as we understand it, with clients coming in the door, and how to begin to resolve that problem through legal action or quasi-legal action. So, John, why don't you start out by describing the problem a little bit to us?
Okay, I'd be happy to. And these are tough situations we're seeing. We are seeing proposed disenrollments of individuals from the Ohio home care waiver. A lot of times the issues are centering around nursing care, whether somebody truly medically meets the criteria for these waivers. Some of these individuals we're seeing are very disabled and very much in need of care. Now, our understanding is this has been going on for at least the last 9 to 12 months. It's across the board. It's in every county of the state. Now, the Department of Medicaid, which administers this waiver, has said that it hasn't changed its interpretation, but we are seeing people that have been on the waiver for many, many years and they haven't really changed, and now all of a sudden families are saying, we're being told that you no longer qualify. An example recently that I represented, a 14-year-old girl. I know, Blaine, we talked about this case as it was going on. Mm-hmm. We were successful with a child with serious seizure disorders, serious disabilities, and really the loss of the waiver services would have been crucial. Her family could have been torn apart from this. So we want to talk about these cases, and thank goodness the family was crying when they got the decision that they were going to be able to stay together. And so today, this is more of a practical explanation of this process and what families and the SSAs can do.
It seems to me the focus almost exclusively on nursing, although what's really confusing to me is they approach it from different angles.
A lot of different angles.
Different sort of legal angles that's saying you don't need the nursing. And I will come to some of those angles, I know,
right,
later on, but just the scope of the problem is not that you can just look at one definition and say, this is why they did it. I'm finding I'm arguing different pieces of the statute each time I'm arguing one of these cases.
And these are some confusing rules, but fortunately we're gonna talk about that today. I mean, what are some of the consequences, Blaine?
Well, you know, the consequences go beyond just losing the waiver. We're here about waiver disenrollment, and the question then is what happens if you lose the waiver and you have other services available or some way to provide
Shouldn't you
service.
just be fine?
Shouldn't you be okay? Well, the challenge is that you also lose what we call community Medicaid. Sometimes you'll hear people call it straight Medicaid. This is just the average. This is Medicaid that everybody would get if they're impoverished. You get that automatically when you're on a waiver. Mm-hmm. If you lose the waiver, you lose eligibility for that unless you come into the eligibility guidelines in any case, which means you have to be at 138% of the federal poverty level.
So if you're working and maybe a couple of parents working...
Yep, you're going to find that you're not going to qualify for community Medicaid. And so now you're losing all access to health care, not just the nursing that you were getting or other services on the waiver, but now you don't have any means for health care. The other consequences is, and there seems to be this leaning on the developmental disability system, the DD system, to provide waiver services if someone needs them. Well, we all know that the DD system is stressed. There's waiting lists. There's economic constraints on waiver availability, and some of those economic constraints are state and local funding. The other thing that's a risk is we're seriously placing people at risk for institutional care.
And isn't that something we're not trying to do
anymore? It does seem like we're supposed to be going away from that. And isn't that the reason for the entire waiver system in the first place?
I think you're right.
It's like all of a sudden we're saying, well, you know, we think institutional will work better for you.
Okay.
When after, 20, 30 years, we've been telling them to get out on a waiver. And so, and I don't want to be too cavalier about it. But the fact of the matter is that some of these people will end up in emergency rooms and hospitals and institutions, maybe ICFs, if they don't get the kind of care that they need.
And what if they stay in the home?
If they stay in the home, then the question is going to be whether or not it's going to create just this really seriously significant health risk. Yeah. So now I've got somebody in a home who might be having cardiac issues, and and that could result in death.
Yeah.
Now, how do you tell a family that that's okay?
That's my most recent case, breathing 24/7.
I've got one right now with a cardiac issue. And there's no assurance also once you go off of the waiver that you can turn the waiver back on. These aren't things that you say, okay, this month I have a waiver and next month I don't. You go off of the waiver and suddenly
It's a loss.
it's a loss. And there's nothing that says you're going to get back on the waiver, especially with the nature of waiver funding.
Because that gets to the point. A lot of these families are getting notices that their child is stable, right?
Yeah,
but
they're saying
they
they're
need the
okay, and-
services to be stable.
Yeah.
So
Well, we'll get to that in a second. But
you'll do these
so
families,
anyway,
yeah.
there's real consequences of these families, and I don't think that families really understand this. They're getting these notices in the mail. Frankly, the assessors are showing. I'll talk a little bit about this in a minute, but the assessors are showing up in a fairly safe way, and all of a sudden they're getting notice their kids kicked off of a waiver.
They're coming in smiling,
and bad
and
things
people
are
may be
happening as a
crying
result.
afterwards. Yeah.
So then the question is, what for the audience here? I'm assuming that we have SSAs watching this video or audio, listening to this audio, and some families too. But I think there has to be a close relationship between SSAs and families on these matters. And the reasons for that is because a lot of these folks are engaged in some fashion with the DD system.
Okay.
They might have gone through an evaluation, or they might have talked to people in the DD system, but frankly, the DD system is the friendly system
But
to deal
it
with.
could be remote too.
It could be remote, but the DD system's in the county.
Mm-hmm.
Most of the DD boards are pretty approachable folks.
Yes.
You're not calling a number and waiting on a. So there's got to be this close relationship with the DD system, and I think people who work in the DD system need to be able to explain to families a few things. One is to explain priority status and how the waiting rules work, so the families really understand the gravity of the situation.
Because they may not get it
They may not get it, and they may be told, "Oh, that's okay. The DD system will take care of it."
by the Medicaid folks.
Yep. And I think that you also have to be able to explain that what would happen if no IO waiver is available, because most of these people are going to come from a waiver that has a level of care that takes you into an IO situation. The kind of services that are needed are probably not level 1 kinds of services. And so if there's no IO waiver available, and there usually isn't, you've got to be able to explain to families that they've got to appeal to keep their services in place. And that's a critical item. I think you also need to understand the options that are out there, not only for families, but what the system is telling families. First of all, there's private pay nursing. Someone can pay a nurse to come in and do the kinds of things the state.
If they have lots and lots
That
of money.
costs a lot of money.
Sure.
There's Health Check, and that's the big thing you'll see the Department of Medicaid rely upon. Health Check is a state plan Medicaid service. You've got to qualify for Medicaid to be able to get Health Check. And like we talked a little bit ago, there's no guarantee that you're going to qualify for Medicaid if you lose the waiver. The DD waivers, if there's nursing available, we're talking mostly about nursing today.
There's a proposed rule to that effect.
There's supposed to be DD nursing coming, but it's going to be economically driven also, and not necessarily available to everybody. And I would especially think that if you're coming out of off of a waiver or into a waiver, into an IO waiver, where someone's already said you don't need nursing, you're going to have a harder time making your case for nursing. So, it's a
It's
challenge.
definitely not clear yet.
I can't guarantee that for anybody, and neither can anybody in the system. There's institutionalization, hospitalization, ICFs. I think it's crazy to
So it's kind of a
have to
sad-
say
yeah,
that.
Yeah, it's a sad thing.
Yeah, that's one of the things that's out
Because
there.
that's splitting up a family.
That's splitting up a family, and it's just wrong. I mean, on a certain policy level and personal level, it's just wrong. And then there's natural support. Some family members, quite frankly, are well trained to provide some of the care that they provide. I've got a client right now, and
But they can't do it 24/7.
they can't do it 24/7, and it's
They gotta
very,
work.
very stressful.
Yeah.
Everybody knows that caregiving stress is a very high stress item, and so I don't think to rely completely on natural supports is the right way to go. So we talked about appeals, John, to keep services in place. Can you talk a little bit about the legal action that might be required?
Sure, and I think the most important thing that if people are listening and they're in a situation where they might have to appeal, you have to take action quickly. You have to file the due process request for state hearing within 15 days of the notice. And why is that important? Why is it critically important? Because if that request isn't made within 15 days of the date of the notice, the services don't have to remain in place throughout this appeal process.
So I get this appeal, but I might be.
You've
I could
lost
be-
it, and your
yeah.
child may already be in an ICF or in a hospital.
Or worse.
Or worse. Yeah, we don't even want to contemplate.
Right.
So That is crucial. And absolutely, though, the appeal has to be made within 90 days. And unfortunately, a family that's out there, maybe the SSAs are going to be more familiar with these rules, but a family may be told, well, you have 90 days to appeal. It's a trap. 90 days to appeal means if you appealed in 16 days, the services aren't going to continue. If the services continue, somebody from the state or one of the contract agencies will go out. The way they do it, I think it's kind of a little bit goofy, but they reissue the plan as it was to continue during the appeal process, and so that's a good thing. And you know, and we're talking about these assessments in general. The people have been very professional and so forth. It's not that issue. It's really an issue of how the rules are being interpreted. The other option, and we're going to talk about it more, but it's really an alternate option, and that's to file a federal lawsuit. And I know there are some attorneys have taken that tact. You really have to do one or the other, and that gets into some complicated federal rules about how the federal courts work. But the other key takeaway is if you don't do, so the first one is if you don't appeal within 15 days, you really are in danger. The second one is if you don't do either of these options, the federal lawsuit or appeal within 15 days, it's going to be virtually impossible.
You're out. You're basically out. I can't
Disenrollment
imagine a
is done.
circumstance I'd advise anybody that they've got an option beyond those appeal thresholds.
No, and you know, most families are not going to be able to file or hire an attorney. I apologize. You know, there are other options here that, you know, I think these can be reasonable, such as maybe contacting your government officials. I think they can be helpful. I think that it also, though, has to have an appeal filed, and I think there has to be a presentation of a case.
Yeah.
And when those all go together, I mean, because when you call the local state representative and say my child's health is in danger, I think they may take notice. And I do think that the people at the department, they're human beings. I think whatever is happening, I ascribe ultimately good motives. I ascribe that they don't want people endangered.
Right. No, I don't think anybody's doing anything out maliciously or to be mean. But I do think that there are a lot of government officials that really don't understand the consequences of this to families. And I think there may be some legislators out there who understand that they want to make economic decisions about the state budget, but they need to see the lives on the end of that too.
And just a paper review is not always going to show what's really going on. No. So what is the level of care?
So we're using level of care definitions, and we could spend a whole day just doing level of care definitions. In the administrative code, they spell out what level of care you need to qualify for different kinds of things, and there's a hierarchy of level of care. We're dealing with the home care waiver and the Ohio home care rules, and so you'll see those on the screen. And the rules for the home care waiver are specifically listed there on the third bullet under level of care definition.
And those can be found on the internet.
Yeah, if you Google OAC and one of those numbers, you'll get the code. It's all on the internet.
You can read it for yourself.
But I wanted you to pay a special attention to the nursing facility level of care, because that's the level of care that brings in the services that are needed for someone that we're talking about.
And that's in the OAC 5160-3-05 to 3-08. I believe it's in 3-08.
Yeah, I think it's 08.
Yeah.
And so it's a rather confusing statute, frankly,
Very
but it
much so.
includes two levels of care.
I mean, you and I have gone back and forth over
we've
this
argued
sometimes.
over this thing sometimes, what it means. It incorporates two levels of care: the intermediate level of care and the skilled level of care. Now, when I say intermediate level of care, those of you in the DD system may be aware of the ICF IID level of care, or what I think they're calling now the developmental disability level of care. It's not that level of care. It's not the intermediate care facility level of care. The intermediate level of care is defined on that. And the importance of knowing this level of care is this is where you're going to argue for skilled nursing.
The golden goose.
And there's an important part of this, I believe it's in skilled level of care, where we talk about the unstable medical condition. And that's one, remember we mentioned earlier that, well, I think we mentioned earlier, I don't know, did we mention earlier? We didn't, we're mentioning it now.
We're mentioning it now.
that the state is approaching these arguments from different perspectives. I've been in a handful of these cases, and it seems like I'm arguing something different every time.
It's a moving target.
But one of the places is the unstable medical condition
And I'd say
that's
this is a
in
big
the
one.
level of care. And I think that is a very big one. And John, you've had some experience arguing this one recently, so why don't we turn to you and tell us a little bit about the unstable medical condition?
Okay, follow me if you will. And for those of you looking on the screen, we apologize for the size of the font, and this is a complicated rule. I've been on a phone discussion with a doctor specialist, and asking for the medical opinion, which we're going to talk about, is so important. And the doctor literally getting this rule and getting ready to say, sure, I'm ready to talk to you and do an opinion. And literally you hear a pause, 20, 30 seconds. And it's like, I'm going to need some time to read this and study it. But this is the rule. And each one of these prongs, A, B, C, and D, matters. So the first is the overall, this is to be on the waiver, you have to have the unstable medical condition. That's how, if you have you're in the DD system, but you are on this home care waiver, you have an unstable medical condition, and that you have clinical signs and symptoms that a physician has determined are the signs and symptoms are outside of the normal range for that individual.
That seems kind of an odd statement to me, John. How do you read that?
Well, I tell you what, I read it very differently than the state does. I read that to mean that if an individual has a disability or a condition, that's outside their normal range. Their normal range is to be a typical human being who doesn't necessarily have the need to be on a breathing machine.
Then someone disagrees with you, I think.
Oh, the state strongly, in fact, vigorously says that's not what it means. Now, the nice thing about these appeals are you get to argue what the words mean, and ultimately that can go up to a court. But because that's the way the state interprets it, we have to be prepared to win the case, even using their own, they talk about if the ref is against you, you got to be able to, still beat the ref too. You've got to be able to use their definition or how they're interpreting it, because that's circular.
That's what I say. It seems to me that if you go with the argument that it's the normal conditions for the individual and the individual's condition worsens, does that now become the normal condition for that individual?
Well, you were losing me there, Blaine, because it's so confusing. So no, here's the question. All right, so you have such a condition that you may have quadriplegia, be vent dependent, and they now say that that's your normal sign and situation, and therefore you don't meet criteria A. They will literally argue that with a straight face. I have people in hearings that look at this, everyday witness, grandfather who's a police officer, seeing that interpretation, and they're saying, it's circular. But in any event, the way around that, the way I look at it is, the way you get it is, you argue the PRN. What I'm finding in PRN, I looked up the Latin, but basically it means as needed. And a lot of the plans that individuals who are on these waivers, they'll be laced with PRN. And what does PRN require? It requires discretion. And in the documentation itself, you could find that if things are inherently unstable or changing, I don't think they can argue that their condition is inherently unstable, therefore they're medically stable.
Okay.
Because that's there. Now, the next two, the prongs B and C, probably are not going to require as much care in terms of it. You've got to look at them, you've got to prove them, and ultimately we're going to talk about it's the state's burden to prove otherwise, but practically speaking, the family, the SSA, or the lawyer has to make this case. They require extensive monitoring, ongoing evaluation. There's supported diagnostic or ancillary tests that justify frequent monitoring or adjustment of treatment. There are going to be LPNs that are coming out, and they're going to keep logs. And in those logs, there should be changes. I did such and such PRN. I flushed a G-tube. It was needed. I had to give a diuretic. I argue that they're making changes, and those are adjustments. And certainly, there can be adjustments in the plans themselves. Changes in the medical condition are uncontrollable or unpredictable. Seizures, if somebody becomes too backed up, I mean, it could be potentially fatal for individuals with serious enough disabilities. Again, that's going to require nursing or medical testimony to show, a doctor's letter. But those two, I think, in serious cases are fairly easy to establish. The other prong, D, and I know we spent a lot of time on this slide, but people really have to look at this and know it. So D talks about there's got to be a licensed health professional, must provide ongoing and assessments, resulting in changes to the treatment regimen as medically necessary, and it has to happen at least monthly, and it has to be documented. There's a lot to that rule, but what I want to focus on first is I've seen it here, and they've acknowledged that an LPN is a licensed health professional, so it doesn't have to be the doctor. And again, when you've got PRN, you've got adjustments. It's better if there's doctor's orders, and you will find those in the case records if there have been doctor's orders. But sometimes it might be the family actually calling the doctor. That happened in another case, and I had a doctor's testimony, the family practice doctor, saying there hasn't been an occasion where the family hasn't called me at least once a month, and where I've had to make adjustments, whether those are documented or not. And the last point of this rule, I don't think the state can fairly hold against a family. It says they have to be documented. Who is responsible for the documentation?
They're saying the nurses are.
The nurses. Well, who is responsible? It can't be the person who is so severely disabled or their family, and yet they'll deny the services. That I don't think they can do, and because it's putting an onus on a family to establish something that they're not themselves required to document. So that's the key. But Blaine, so now we've got this, and again, medical necessity is a big concept, but what is this disenrollment process?
So let me talk a little bit about just how this comes to a family's front door. Generally what's happening is ODM
Ohio Department of Medicaid.
Ohio Department of Medicaid can perform an assessment. And at least in some cases, they're using something called the Program Eligibility Assessment Tool, the PEAT. And this is a multi-page sort of checklist, fill-in-the-box kind of form. The meeting with the family, the state can do this as a desk review, or they can do it in person. They tend to do it face-to-face. And the meeting with the family, at least initially, seems like just your annual redetermination.
It's all good.
All good, everything's fine. And this information is filled out and taken. Then the PEAT is reviewed by the Department of Medicaid and to determine whether or not the services are medically necessary, and in some cases whether or not you have a unstable medical condition. The PEAT, I'll come to medical necessity here in just a second, but I also want to point out that the PEAT includes an ICF-IID level of care tool. So the last 2 or 3 pages of the PEAT has in it a checkbox. It's really just a checkbox that says, do you have these substantial functional limitations?
Sounds like beware of the PEAT.
Beware of the PEAT. Thank you. I'm not sure what that means.
I'm not sure either. It can be very good for you, the PEAT.
Anyway, the last few pages have, those of you that work in the DD system know the level of care assessments you do for individuals with developmental disabilities. It's quite complex. Takes hours to do, requires a high level of training and skill. That's not what happens in the PEAT. It's really just a checkbox, whether or not you have the substantial functional limitations to meet the ICF-IID or developmental disabilities level of care.
So the Department of Medicaid folks, their contractors are making
They're making that determination. And what's important about that is if you reach that level of care, then you don't have an intermediate level of care that we talked about earlier. And that's one of those sort of threshold levels of care that gets you into the Medicaid system and might be part, at least, of the analysis for whether or not you meet the skilled level of care. So you've got, they're doing this rather cavalier ICF-IID checklist. They're determining whether or not you're medically necessary. Now, medically necessary is a foundational concept in Medicaid.
Yeah, why should Medicaid pay for something that's not necessary?
It's right. You've got to have medically necessary needs in order to receive Medicaid.
Makes sense.
I'm not going to go into the medical necessity definition, but I do want you to highlight 5601-01 and look at that. That's the rule for medically necessary. And pay attention to how they're using that rule. Make sure that they're applying that rule correctly and that it's accurate to the new statute.
You're telling me to do that, or do you want the families?
I want the families to make sure that they're looking at that rule and matching it up with what they're seeing come in the front door. So, John, there's this no hospitalization within 30 days that we've seen on a couple of these evaluations. Why do you think that that's showing up, and what's the importance of that?
So, as we talked about earlier, Blaine, the state is saying that it's not changing how it interprets its rules, and the rules themselves haven't changed. The rules are what the rules are. But what we're seeing in the PEATs, there's a narrative part of the PEAT, and we're seeing it, and it says not just no hospitalization, but it may say no medication change, no doctor's visits, no hospitalization within 30 days. To me, that's another one of those where you go, beware the PEAT. Beware the way the PEAT is being administered right now, because for whatever reason, be it a directive from the department or how it's being interpreted, on paper review or coming out to visit the families, they're looking at like a 30-day period of time, and they're saying, well, you haven't been to the hospital, which may be part of the plan, that the individual doesn't go to the hospital and they're not going there because they're getting nursing services.
Yeah, and I'm a little troubled by that sort of catch-22 that you put families in. If the nursing works, then you don't need the nursing, is what I start to see. And no hospitalizations, well, the no hospitalizations because the nursing works. Without
Good job.
the nursing, yeah, good job. We're going to take it away now, and now you got to go to the hospital. So there's a catch-22 I see.
And that's not in the rules. So when
No.
we're going to talk about arguing it, that's not enough. That's not what the state has to show.
And so speaking about arguing, there's a right that everybody has. It's called due process. And
Do
many
tell.
Many of you in the DD system know the term due process. I was on a county board for a number of years, and I remember hearing occasionally the SSA director talking about somebody going to due process. And it's always sort of this big nebulous due process. What is due process? Well, due process, whether you know or not, actually comes from the United States Constitution. It's the 14th Amendment of the Constitution that says that you'll not be deprived of life, liberty, or property without due process of law. And through some decisions that have, at the Ohio Supreme, at the not at the Ohio Supreme, the U.S. Supreme Court, well, the Ohio Supreme Court too.
Yeah.
But the U.S. Supreme Court has ruled that entitlement programs are a property right because they're entitlement programs. So programs like SSI, programs like food stamps, programs like Medicaid
Sure.
are entitlement programs, and they're a property right, and the state cannot deprive you of that property right without due process of law. Now, due process of law is kind of not necessarily a trial. You don't all of a sudden get this right to go into court. What you have is a right to at least an administrative review at the beginning to make sure there's not a mistake being made.
It's kind of like a second check.
It's a little second check. But you do have the right to see the state's evidence, produce your own evidence, and confront the state's witnesses at these hearings.
That's good.
The hearings are conducted, and due process rights are sort of ratified, if you will, by the Department of Jobs and Family Services Bureau of State Hearings.
Wait a second. The people that decide the case are actually part of the...
Well, to the extent that they're the state, yeah. So the state's deciding you don't need nursing, and the state's hearing your at least initial levels of appeal. That's constitutionally allowed, but it does catch families off guard. I think you should explain to them that it's the state of Ohio. They're going to be very suspicious about that. I can tell you that from my experience, these are fairly well done hearings. I think the hearing officers try to get information. I do believe that going in the door, there's sort of a presumption that while the state has has the burden of proof on these, we'll talk a little bit about that in a minute. There is sort of a presumption that I feel like you're going in the door and you might
You're at
lose.
an uphill fight.
So the hearings sometimes are conducted over the phone. I've done these over the phone. I've done them in person. Usually the state's on the phone. The most recent one I actually went to the Bureau of State Hearings and held a hearing in person. As John mentioned earlier, you got to file for this due process within 15 days to freeze your benefits in place, and 90 days in any case. For most people, something called an authorized representative is necessary. The authorized representative is a person that can speak for the person making the appeal. So you'll find that that's going to be necessary in a lot of cases to interact with the Bureau of State Hearings.
To get in the door, really.
To get in the door. If someone with a developmental disability doesn't have an authorized representative and I called them up, the Bureau of State Hearings basically, and Department of Medicaid wouldn't talk
How
to
do they
them.
become an authorized representative?
Well, there's a form you fill out, and
Always a form.
you submit it. You sign, the person that's appealing assigns it and says, "This, I want this person to be my authorized representative," and you send that
Does it
into
have
the
to be an
Department of
attorney?
Medicaid. It does not have to be an attorney.
Okay.
I think it's important, necessary. We're going to talk about getting the case file, and we had a question at one of these sessions we did recently, and they said, "Can I get the case file without just by calling the state?" You're going to have the authorized representative. You're going to have to be an authorized representative to get the case file. They're not just going to give it out to anybody that calls. So, we're going to talk about getting the case file, but you'll need to be an authorized representative to do that. And so, John, when you talk about when we talk about due process, how do you get this thing rolling? What do you do to get going?
Well, you've got to file it. That's the first thing. And when I do a due process case, I typically don't just fill out the form. There's a form in the back of the notice that allows the family to request due process. I think that's perfectly acceptable. I like to set the case initially with a few paragraphs saying this is what they're doing to my client, this is why it's wrong, and this is why we want an appeal. Because in my experience, the hearing officers have already read this, and I typically will do an appeal summary too, not to give away too much of the case beforehand because these things are happening live, but to at least set the stage.
I do the appeal summary sometimes. I don't always set the case when I ask for the hearing. I usually just send an email saying I want a hearing.
I want a hearing, and that's fast and effective. So
and you
totally get that.
you can request the hearing by phone. You can request a hearing by fax. You can send a letter in to the Bureau of State Hearings.
And I typically do all three, but that's just me.
I do fax, and I send everything certified mail, and I send a fax too.
So you get the idea. We want to make sure that your hearing rights are protected, and that nobody's unhappy with us.
And
but
we're attorneys.
We're attorneys, so why not do three? One of the bedrocks of this is that the burden of proof is actually on the state. It may not feel that way. You're going to go into a hearing, and the hearing officer is going to either be on the phone or maybe there, and it's going to seem very serious. Although they'll be friendly, they'll swear witnesses in. But this is going to happen so quick. These hearings may get scheduled 2 to 3 weeks, sometimes a little bit longer after the appeal time. There's the possibility to get a postponement, but in the cases we're talking about, we're dealing with some pretty serious complexities, particularly with the medical, getting the notes, the nurses' notes, the caregiver notes, the plans are all going to be so important, and it's going to take time to get those.
And the family's going to come to you like they never come immediately when they get
3 days
the
from the hearing.
Right.
It may be.
They're going to come to you right away, or they're not going to come to you right away.
So no matter what, the family really has to request a postponement, and the time needs to be to review a file, hire legal counsel if that's the path they choose to do. Anything, if there's a key witness can't be there, that's good cause. Oftentimes the state will only grant one continuance, but if there really is a good reason, they'll grant another. Now, when we talk about requesting the file, it's important to request the entire case file. I typically request from the providers, but Blaine, I understand you typically go through the Bureau of State Hearings.
I've done it through the Bureau of State Hearings. The challenge that I find that families have is they're not sure who to be contacting. So they're being told to contact the Bureau of State Hearings to have an appeal filed. The actual right to the case file exists in the hearing rules. And so I go to the Bureau of State Hearings to document that, but I'll also contact the state Department of Medicaid and say, just let you know I'm requesting the case file.
And I think it would be helpful grounds for a continuance, because the key thing is the state's required to do a case summary. And my experience is the state will often simply read its summary at the appeal. It can be a boring 10 to 15 minutes, quite frankly. But you need the case file. The case file is different, and that's the key, is to request the case file, and it can be very large. And if you haven't had it in time to prepare for the hearing, you need that.
The case file is going to include what, John?
Well, that's an interesting question, because from what I've seen, it's not always consistent, but it should include, if there's a contract agency that's reviewing it, should be all the CareStar notes, there should be communications logs, there should be, I'm forgetting the name, but I think they're the 486 plans,
Yeah.
if I'm right on that.
I think that might be.
Yeah, the doctor's orders, if there's a provider agency, to me, that's part of the case file. All of those logs that the providers are doing. Now, especially if the providers are friendly to you, you may be able to get them fairly quickly. And this can be expensive. So if you can get it through the state, there's not a cost involved, but there may be copying costs.
Well, I think what's important about the case file is it tells you what the state looked at. What's interesting to me is you may think the state's looked at a year of records, and they may have only looked at a few dozen records. Or
it may be a lot smaller than you think.
I had one. It's an annual review, if you will, but they looked at 12, 14 days worth of records. So the case file also will tell you if there are some limitations on what the state looked at, and so then you've got to augment the record a little bit. You know what you need to come in with more.
And it's to an advantage, because if the state looked at 12 or 14 days of records and they're trying to prove something for 30 days, we'll let the audience, figure out the argument there. And, the other thing, people might be intimidated, but there's subpoena power. And why is that important? Because you can require someone to be at court who has important evidence. It's not that hard to, there are limitations.
Now, all of us lawyers, we know about subpoenas, and we do subpoenas, and it sounds like some really fancy legal.
You need a legal magic wand.
You need one of these legal things that we got, some trickery. How do you actually do a subpoena?
You could email the Bureau of State Hearings or even call them. They would want something in writing. They would need to know who the witness is. They might ask about the relevancy if there was some question. It's not good to subpoena the governor, but if there's a witness,
you probably won't get the governor.
You probably won't get the governor.
You probably won't get the rep, but you can subpoena other witnesses.
But there are other witnesses, and it could be somebody, even from the DD board, potentially.
Yeah, I think there's a question out there often about what the DD board's role in some of these, and the SSA might be an important person to have, but the SSA might not be able to be there. There might be some restrictions on time or whatever. You can subpoena an SSA to be there too, and it's not a mean thing to do.
No, not at all.
Everybody gets that. Now, the subpoena power can be, the hearing officer can say, no, we're not going to give you a subpoena.
That also
that
becomes
might give you another reason for appeal.
Grounds for appeal.
Yeah, lawyer tricks. So anyway, what about this federal lawsuit thing, John?
All right. Well, some families are going to be in a different position, and they're maybe not going to trust the state appeal process. There is a right to go straight into federal court. It's under the it's called 42 U.S.C. Section 1983. And
we call these 1983 actions.
1983 actions. If your rights have been deprived that were secured by the Constitution or under federal law, a.k.a. the Medicaid program, there is the right to go straight into federal court. There's not an automatic stay of benefits, but I think that could be arranged through a temporary restraining order. But I would say this, it would almost certainly require an attorney. And I think from the federal court standpoint, it can't happen as quickly because federal judges are not as versed in the ups and downs of the day ins and outs of administering a Medicaid waiver program.
Yeah, I think your federal court options are something to know about, but it's a long slog. The federal courts are crowded, and to assume that the state's going to react quickly to a federal court action is probably a bad assumption.
I would agree with that.
And so now you're going through your due process, John. You're not in federal court, and what exactly do you do?
Well, all you have to do is be a brilliant lawyer, Blaine. That's it. But
that rules us out then, right?
We're in trouble. This is bad. No, look at the slide.
Where's the banjo music?
There's a big. All right. It's a mixed. What does it mean to be a mixed legal medical case? It means we, the brilliant lawyers, can't necessarily win. It means these cases are driven by medical necessity, unstable medical condition. But doctors are going to look at some of these individuals and go, of course, she's medically unstable. If she has on a breathing machine, she could die. So families have to be always building these cases, working with the providers and the professionals. I've definitely taken the time to work with the nurses who are going to testify or the doctors who are writing letters to really help them understand the rule about unstable medical condition. And it's going to depend on what the denial notice says and what the PEAT says. But to prove the case, you need to start building the evidence to rebut it. Now, yes, the burden is on the state, but the practical burden is on you, the family, or an SSA who's helping, or a lawyer, to get all the records and explain just how seriously disabled this child is, or this adult.
Do the SSA records play into this?
Oh, I think they're huge, and because the state, as you said earlier, is going to be making the argument, well, they can just go over to the DD board. And in some cases, that may be the case. And if that's true, and a family knows it's going to get an IO waiver, and it looks like there's going to be nursing services, I've actually seen this now, the transition for one of my clients was agreed upon, and that once they would keep the IO waiver until the DD nursing services were available, and we could always appeal at that date if we were uncomfortable with the care being provided. They took that. So that was a way of going forward. But in many of these cases, the DD system is not going to have a slot available. So you're looking at institutionalization or trying to serve, the family, somebody stopping working and trying to keep their child at home. So these are crucial cases to have ready to go.
And I think it's important as you prove your case, you're going to use all these records that we've kind of listed. So you should hang on to everything. I tell families all the time, hang on to everything you've got. I don't care if it's boxes and boxes of stuff. The other thing I would say is make sure people are writing accurate things in your records.
Oh, that's huge.
I had a case just recently where the nurse wrote that someone could eat a salad, and there was an allegation that they could eat solid food instead of soft food because they ate a salad. Well, it was a souffle, and the nurse wrote salad, and that was used against my client. And so what you want to do is make sure all these records are accurate. I tell schools this all the time. Don't write.
They're trying to be positive.
They're
right?
trying to be positive. They're trying to say nice things, and they're trying to give them a warm fuzzy. And these organizations are taking some of those records and use those rules against them. So keep all the records that you have. You're always building your case. And I'm sorry.
No, it's good. In my case, it was the child can eat solid foods. Well, occasionally she could have a cracker being monitored. Otherwise, she would asphyxiate. That's the testimony that comes in versus what's in an IEP. So.
My child couldn't chew. It's like, come on.
But this is it. You have to because they're trying to say go to the DD system. You have to show the skilled level of care, and that's again the medical necessity for the nursing services. So let's move on. And what do we talk about? Oh, in terms of proving the case, I think the bedrock is you need medical testimony. And not to be stereotypical, but in the legal system, doctors trump nurses. So if there is medical MD, DO testimony, particularly specialists, they may not show up at the hearing. I was prepared in my second case to have a retired doctor come in and do that. But most people, probably the best you're going to get is a well-written letter that you've helped the doctor write that's accurate and is done within a high degree or a reasonable degree of medical certainty. Those are buzzwords in the law that make it legal, that says I am putting my stamp of approval. Again, a high degree or reasonable degree of medical certainty. You need that to show the unstable medical condition or medical necessity. You can't just rely on family knowledge. I think it's great to buttress that because you understand what life is really like with your loved one. And then the other thing that has to be done is you have to hold the state to the procedures. Blaine, you have one that I just get a chuckle out that you've done recently. Why don't you talk about that?
What do you mean?
I'm talking about the one where they're using the statute changed a year ago and they're using the wrong statute.
Well, that's what they're doing.
So I'm hoping you win that.
I suspect that they won't do that anymore.
But then probably not. We probably caught them on that.
I mean, you've got to watch what the state's doing because there are procedures written into the law. We mentioned the subpoena statute there. That's where all the state hearing procedures are. So make sure the state's doing what they're doing. There's procedures for doing the assessments. Go through those procedures. Make sure the state's following their procedures. There's reasons for those procedures. Those procedures are in place to make sure people have due process. And so
and
make
it's hard
sure
for them to prove
they
can't really meet their burden if they did it wrong.
Right.
And that's kind of the technical legal, and maybe we're a little more comfortable with that. But if the procedures weren't followed, as a family person, you need to make that clear. But at the bottom line, end of the day, what is being accomplished here? Your child, your loved one has a serious condition, and the consequences of losing this benefit of the waiver program are serious. There isn't necessarily DD services available. There's maybe institutionalization or risk of serious harm to your loved one. And the goal here is to make that hearing officer feel uneasy.
Yeah, I think it's really easy in these cases to see these as just paper. And it's hard for a lawyer too, frankly, because our job is to kind of be the dispassionate one, the one that's looking at the law. But I think what you've got to do is make sure everybody understands that there's real lives on the ends of these decisions.
Totally.
And that includes the hearing officer. Absolutely. I don't mind talking to the state about real lives. I don't mind talking to politicians about real lives. And I don't mind telling the hearing officer what's really going to happen. And so make your family member real.
And that you may need the help of the DD board really to explain that, or the SSA.
Yeah, and
or a letter. I've had that.
And so in proving your case, how can the county board help? Well, first of all, I think this notion that there's a reliance on waiver eligibility, I was part of the DD system, I know. And
you're a board member.
That's just, it's not real. And so this overstatement of, well, we'll just make sure the DD system takes care of somebody is not.
Or they can have community Medicaid. They're fine, right?
Right. It's beyond the scope of the system to do that. So reliance on it to me is a little bit overstated. There can be testimony about the DD system's ability to provide some of these services. We talked about the availability of nursing and whether or not that makes sense. We've got expertise from SSAs and other professionals in the DD system about medical necessity. Now, I recognize that in some cases there may be some pressure because
or conflicts,
and so I might have to subpoena SSAs, and I think from family members I would have no problem telling them to subpoena an SSA, and then that gives the SSA a little cover to to do what they have to do.
No, it's not just cover; it's a legal obligation.
Well, yeah, as a matter of fact,
Let's
it is.
It's called that. It's called the law.
And then you also have documents at the DD system where you might have done some analysis of people that did not result necessarily in waiver eligibility, but non-waiver services. So the OEDI and no COEDI documents are going to tell everybody whether someone actually meets the level of care necessary just to receive DD services in the first place, regardless of waiver eligibility. Those documents are important, and they kind of sit outside of the scope of what a lot of people are looking at. And so I think the DD board can be important in helping sort of present these cases.
Well, Blaine, what happens though if the family's not successful?
Well, and that happens more than you would want to admit. If you're not successful, the first thing that you have to recognize is it's critical in the first phase of this, the state hearing request that you're making to BSH, to start to build a good record. So you're getting things in. They're going to record these hearings, so you're going to say things that you can then use.
It's just a tape recording like the people are listening to now?
Yeah, probably less entertaining, but yeah.
Yeah, definitely less entertaining.
But
not holding ourselves up that high,
of course.
but still.
So anyway, there'll be a recording, and so you're going to put things into the record that you'll then be able to use later on, maybe even in court if you end up in court. But then you've got to file a timely appeal if you lose at the state hearing level. And there's a second level of appeal.
What do they call that?
It's called administrative appeal. And it's really just a paper appeal. So you're going to tell the administrative, you're going to get notice of that, and you're going to file for administrative appeal review. When I do that, John, I also submit additional evidence if I've got it. If it's timely, I type a memo to the appeal. When I request my appeal, there's a memo that goes with that.
Let me interject, because I've seen the argument at hearing say, we're at the actual day of the hearing, the PEAT was done 6 weeks earlier, and in that time there were some serious seizures and medication changes, and I've heard the state say, this is not right, you can't introduce that. And I'm like, absolutely not. The burden on this is on the state to prove its case,
right,
what this individual is, and that evidence is relevant to that determination.
So there's time frames also for requesting this administrative appeal, and you've got to hit those time frames. While this administrative appeal is in place, and if you hit the time frames correctly, your services will still stay in
Meaning
place.
if you did the first appeal in the 15 days and then you
file the timely appeal to the state, the administrative appeal. So you're going to file a written statement and supplement the information that you're doing. I also think it's important to listen to the hearing record before you file your administrative appeal to make sure if you can request at this level copies of other kinds of things also. So it's important to get all this information and rally it around. So that's why it's important to get things into the record at the first one. It's the only one they're going to record. Get it in if you've got information to say, written or verbal information. If you lose then at the administrative appeal, your only option then is to go to the common pleas court. Now the problem that you have is the only way to keep services in place is you're going to have to file an injunction to say that there's more harm than good in removing the services.
And is it easy to then overturn these decisions at a common pleas court in one of the 88 counties?
I don't know that I would say it's easy. It's a long slog again. Whenever you go into court, now you're looking at the court schedule. It might be a year or 2 years before you actually get anywhere in a court, and then if you appeal those actions, you're still
go higher. But in terms of looking at the law, the judge at your local judge can take a fresh look
Yeah,
at
so
it.
now what's happening in court is you're starting over. It's a do-over on everything. The rules of evidence are a little more strict, but now you're bringing in everything that you need to bring in under the rules that the court operates under.
But there is deference to the decisions, the fact-finding, and that's the challenge.
That is the challenge. So there's an awful lot of deference to state agencies general in how they interpret their rules. So you've got to show that they've acted really very arbitrarily in how they've implemented their rules. So my point on all this is you've got more process. It's important to put your best foot forward at the very first stage.
But after the administrative appeal, why can't you just file a federal lawsuit? But the answer to that is because there's federal rules that basically say, well, we're not going to touch it now.
While it's in the administrative process.
And so it's like once you go down that avenue, you've got to assume you're going to complete it. But so, Blaine, what would the takeaways be about this procedure and what's happening?
Well, the first takeaway I'm going to add, I think I might have it in here somewhere, but you're always building your case. You're always make sure that you're policing your provider's records. Make sure they're accurate. Make sure they say real things and they're clinical.
Among all the other things you have to do in your lives.
Yeah, just make sure, because they're going to use bad records against you and they're going to say, well, that was the professional's determination of what that said.
Because doctors are signing off on these forms not knowing they've changed, that they're now saying you're disenrolled.
Yeah, I mean, you're under an increased burden to just watch how things are said in the record. And I don't think that was always the case. I think it's more intense now. I think you have to respect the timelines. Make sure that you're paying attention to any notices you get. If it says you have an appeal right, you should be sure that you're paying attention to what that appeal right is. You should pay attention at the assessment phase. As I told you earlier, there was a client I came in and the assessment was friendly. I mean, and I'm sure it was. I'm sure the assessor was a nice person and a nurse and very kind person. But it was sort of disarming, if you will. She didn't realize that at that point in time, it might have been important to provide additional information.
Sure, and I've heard of a nurse crying that, hey, I had to fill out this form this way and your child is going to be disenrolled.
Right. So they're doing the assessment. They're taking a record down. And I think that at that point in time when the assessor's there, families ought to be paying attention to what the assessor's doing. I think you should give them more places to look for records. So if there's records that you believe show the need for services for your
But
child.
it's tough. If the standard is no hospitalization, no med change, and no doctor's visits in 30 days, which it isn't, it's going to be tough to change the assessment.
It is going to be tough to change the assessment, but I think you've got to go in and say, I think you also need to look at an IEP, or I think you need to talk to the SSA, or I think you ought to talk to my doctor. He told me something the other day. And I think you ought to make the assessor do more than spend, whatever it is. It might be an hour in your house filling out some forms.
Because in these hearings, this is like multiple levels of hearsay. So there's an individual reading the state's statement of the case, which might have been approved by a supervisor, and there was a nurse assessor that maybe went out into the field. And I've seen in the communication logs, they said, well, Dr. such and such supports this. Well, when you look in the communication log, all that ever happened was phone tag.
Yeah, and it's just you've got to respect what's happening at that assessment. What's happening at that assessment, regardless of the need. The assessment is for the purposes of determining whether or not you still need that nursing, whether or not it's medically necessary, and whether or not there's an unstable medical condition. And it's that. It's not an assessment just to make sure that you can continue benefits. It's an assessment to make sure to determine whether or not we should terminate benefits is the way I think families ought to look at it. People should understand this is a quasi-legal process, as John mentioned earlier. This isn't just...
What does quasi mean?
Well, that's a good question.
Kind of, sort of?
It's sort of legal process. It means that you're not going to be at a trial, so don't feel like you've got to have Matlock on your side and make all these formal motions and stuff like that. You're going to go to a hearing and you're going to make your argument. And I think that you've got to respect that it's that kind of process. As John mentioned, there's a lot of hearsay in these things. You would never get some of the statements that people make at state hearings in a court of law. They just would get thrown out in a lot of levels. But this process is a little less formal.
It's less formal.
It's quasi-legal.
It's quasi-legal.
Build the case before the hearing. and try to postpone the hearing if it's necessary.
It almost certainly will be.
If on these cases, it almost certainly is.
There's a lot to them.
You've got a right to postpone it to have. You got 3 days to look at the case file, I believe, is what the procedures say. So at the very least, if you don't have 3 days, you get a postponement. You can get postponements for trying to hire an attorney. You can get different. And the state's usually good about giving that first postponement. It's a little difficult
You might have to work
get
for
them
the
down
second. Yeah.
But you've got to be able to have time, and you won't have enough time just on the scheduling, the hearing schedule itself, to do all you need to do and to rally your case, to take your child to another doctor to get an opinion or whatever it might be. So you've got to build your case and get a postponement if you need to do that. You will need medical evidence. It will absolutely be essential. And I'll take anything I can get. I'll take a doctor's letter. I'll take more nurses. John said,
at the very least,
John
you need
said,
nurses.
Dr. Trump's nurse. I say two nurses,
Trump
one nurse, and
what there will end up being two nurses because the state will have somebody there who also is a nurse. So you've got to build it up.
Yeah, it's. I bring as much medical evidence as I can. The hearings officer's job is to sort through all that and write an opinion.
And remember, the burden is on the state to win. So if it's 50-50, you should prevail.
Yes, and so the other thing I always mention is, the last thing I'll mention is that these are very, very hard cases to win. As we mentioned at the beginning, you go into these cases and us lawyers kind of assume that you're going to have an uphill slog.
It is an uphill slog.
They're hard cases to win. So get all these takeaways right. Have your case ready. Get ready before the hearing.
It's a lot of work.
It is a lot of work at one of the most stressful times in a family's life. All of a sudden, everything that's been stable for them is being taken away.
For years.
And now we're asking them to go ahead and do all this kind of stuff.
You reminded me of one argument I want to make sure we get in there because when the individual has had the services and the PEAT repeatedly for the last several years, I like to look at the comments from the couple of years prior. A lot of times they say exactly the same thing, but they may not have the statement, no hospitalization, no and to me, that's evidence that needs to be argued that nothing has changed except the way the state is looking at that individual.
Yeah. So at this point, we would take questions. We had some. I think that we get all of our questions answered, John.
Well, let's see here. We've got a couple. I think this goes back to the PRN issues. I mean, we were debating earlier, should we say names or should we use initials or say nothing?
I'm not using names. If you ask a question on the webinar, I'm not
great
doing
pronunciator here. So I'm going to say, this is from DL. Hi, one of the issues we see are they now these were just typed in, tell families that if your norm is unstable, you're stable. Very difficult for families to figure out what to do. And again, to me, that's that circular argument. And it goes back to responding by, well, that's not what the rule says. The rule is compared to a typical person, but at the very least you have to argue the PRN is in and of itself why the individual is unstable. Another question we had is a federal suit the only way to appeal the decision of the state hearing? And no, that is actually incorrect, that it has to go through the state common pleas. I have one more here. It's, can a point of consideration in the appeal be that the individual's condition has not improved? For example, the individual has had CP and that condition has not changed, so why disenrollment now? That's what I was just getting at with the argument with the PEAT. It's not the individual who's changed, it's the way the state is looking at them.
And the state sort of will say in those circumstances that their condition has improved or stabilized or something like that. This actually troubles me a little bit because it seems like we're using conditions that haven't changed over a significant period of time and saying that they're gotten better.
The plans say, you'll be maintained in the home with these nursing services and you'll have no hospitalizations.
Yeah.
Well, they're there because they have nurses. There's
a lot of catch-22s families are in. And the only other question that we have is whether or not we're seeing disenrollments because somebody's affiliated with the DD system. What I'm assuming is what the question is asking is if they're enrolled in something in the DD system that's non-waiver, are they being disenrolled for that? Directly, no. They're being disenrolled because either a service is not medically necessary or because they don't have an unstable medical condition. But they are relying on the DD service, the DD system. I believe disproportionately. I believe that the DD system, at least as it's currently funded, is not set up to absorb some of what they think it can do, or at least I don't even know what they think that it can do. It's what they're saying it can do. In their evaluation summaries, they are listing the DD system as an option.
Are available. Yes.
So I don't think that there's necessarily an affiliation with the DD system that's a problem, but I do think that there is a reliance on it that's disproportionate. And that's the questions, and I think that that's all that we really have to cover. John, is there anything else you wanted to say?
I don't, other than parting thoughts, it's just tell people, stand up for your families, do what you think is right, get people on your side, seek an attorney if you believe you need that, and we know that you're going to do the best you can for these people you love very much and who need care.
And all I'll say is we appreciate you spending a little time with us today. I hope this was informational for you and that we've helped you help families, or if there's families listening to this, I hope that we've given you a few nuggets of information that can help you with your family member. Again, I'm Blaine Brockman. I'm an attorney at Hickman Lowder, and this is
John Harris, and also an attorney at Hickman Lowder.
Well, thank you for your time, and have a nice day.